Good evening, all of you. Today we are here to discuss the long-awaited and finally passed labor laws. There has been a lot of talk regarding this, that whether this law will be good, bad, whether this law will give us growth, not give us growth. There is also a talk that whether this will be good for workers, how it will affect the society, how it will affect economy, how it will affect productivity, what are these laws, what are the changes, what used to happen earlier. So we will be discussing all that today, and I have with me a very wonderful panel of my colleagues, Nitish sir, Raj sir, and Reddy sir. So, and I am Vibhas Jha, Faculty Economics at Next IAS. So what we will first have to understand is that there has been a final decision now on central government's part that they will be implementing the labor laws that had been passed 5 years ago. So what was the context? Please understand. The Second Labour Commission, which was established in 1999, had recommended that we have multiple labor laws, more than 40 central labor laws and more than 100 state government level labor laws. So they had recommended that ideally they should be condensed into 4 or 5 codes so that it is easier to understand, follow, implement, adjudicate. Somebody should be able to understand how it will be implemented, and it should be fair to both employee and employer. So first question that arises, friends, is that what was the context of our labor law reform? So in 2002, the central government in those days had established a committee to adjudicate on labor laws and create labor codes. But after the government lost elections in 2004, the political party, UPA government from 2004 to 14 did not give a lot of weight to this topic. Again, when NDA government came in power 2014, then again this topic started up. Again, they started framing codes. In 2019, in fact 2018 winter session, there was a 31-member joint parliamentary committee which was set up to formulate these labor codes, talk about them, get the objections. 100 changes were recommended by the joint parliamentary committee, and it had members from all political parties on proportional basis of their parliamentary presentation. And out of these 100, 74 were incorporated, and then the labor codes were passed as wage code in 2019, and then 3 more codes were passed: international relations code, social security code, and occupational safety, health and working conditions code in 2020. However, the state governments were taking their own time in implementing the law, and unless the state governments would not be convinced and they don't implement it, it would be futile to implement the law in India, because majorly when it comes to factories working, enterprises operating, it is the state government which brings it under its perimeter, which we will get to know better with our experts. So I begin my first question, Reddy ji, I am coming to you, that what was the historical background? Like I briefly told the students, but what were the economic issues due to which this labor law was required?
Sir, if you see, for any economic activity, sir, 4 basic factors of production: land, labor, capital, and entrepreneurship.
True.
The basic and fundamental. If you see our country, sir, when we got independence, so there were so many legislations enacted the pre-independent era.
True.
That was colonial era. Their intention is to sometimes favor some employer, sometimes favor employees. So there is no balanced labor laws in our country, sir. So as you discussed, the Second Labour Commission recommended multiple reforms, but because of lack of consensus, because in India, labor is a part of concurrent list.
Yes.
We are a federal system.
Yes.
So there are so many unions, sir may discuss more. So they always play safe game. So they don't want to touch this complex issues, sir. Now the topic is why we need the reforms. Number 1, see right now multiple central legislations are there, multiple state legislations are there.
Yes.
Lack of clarity, sir. So multiple complex labor legislation exists, number 1. So now if a foreigner want to invest in our country or in Indian, anyone want to invest in India, they are unable to understand the law. Let's say in Karnataka they have different rules, in Andhra Pradesh they have different rules, Bihar different rules. So one challenge is multiple complex labor laws. Number two, sir, lack of clarity in the definitions.
True.
So there is a lack, for example, sir, the gig workers are not clearly mentioned. Now after LPC reforms, the way we improved our IT sector in the last few years, the e-commerce, startup India, the whole what you call the labor market pattern changed, sir.
True.
And now the event of AI right now. So number two here is what you say, lack of clarity in the definitions. Sometimes gig workers are not covered. Sometimes third gender, sir. So generally they talk about male and female. First time right now in the new labor codes, they talk about third gender also.
Yes.
So number three, including everyone. So previously some sectors were neglected. And traditionally, sir, only organized sector, establishment sector only covered.
True.
Unorganized sector not covered, informal sector not covered. So that means they want to have such a legislation comprehensive, including all sectors, including all workers, sir. And one more thing, sir, in our country, if you see, right now business or FDI or investment is coming to only few states, where the states are having such a legislations or labor laws which are friendly to the investors or business point of view. So now we need, indirectly it is promoting inequalities, regional disparities, as you know, sir, ease of doing business. Let's say Gujarat, Maharashtra, Tamil Nadu, they are having good land acquisition policies, labor policies, so easily getting credit.
Yes.
So businessman is moving there, so indirectly some other states are get affected.
Yes.
So now indirectly to bring uniformity across the country.
Yes.
And one more thing, sir, traditionally if you take wages example, there is no floor, there are floor wages, sir, but that is not mandatory. So central government says this is the wage, nobody can pay less than this, but it is not mandatory. There is no legal mandatory rule. Now under this new legislation, they say central government says this is a fixed amount, nobody can pay less than this. States may fix more than this, sir. We'll discuss in
But
wages
not less
code.
than.
So now mandatory provisions are there, and traditionally annual health checkups are not covered, not mandatory.
Yes.
And sir, even if you see the hiring was very complex. For example, there is a standing orders. So once a company has more than 100 workers, they have to tell how they will be recruited, how they are going to be removed or lay off. So everything has to be clearly mentioned.
Yes.
So indirectly, the companies are discouraged to recruit more than 100 workers, sir.
True.
They recruit 90 workers, 95, and they
Multiple factories.
they will take contract workers, sir.
Yes.
So they take the third party, not directly recruitment. So there are all traditional challenges with our existing labor laws. So to overcome these problems, if you see Modi government, sir, last 11 years, they took lot of reforms. No doubt. For example, they brought the IBC, wonderful law, Insolvency Bankruptcy Code. They brought the GST.
Yes.
Now they wanted to reforms in agriculture sector, promoting the digital economy, promoting the startups, Make in India. So now we invested a lot in Bharat Mala, infrastructure projects. But for all these things, labor is a key essential factor.
Absolutely.
So now government wanted to take risk because there is some opposition also right now. It is a part of concurrent list. So now government took, it is a third tenure. We must take seriously the reforms so that we can create quality jobs. Right now, we have to keep in global context also in mind, sir.
Yes.
Now the way many trade wars are
Yes.
happening. Now there is an imposition of 50% tariff on our goods. So our exports are get affected. So to make all these things in mind, government want to implement this multiple labor at center level
Yes.
into 4 labor codes. It's like a simplifying so that
Process.
we can improve the ease of doing business.
Yes.
Sir, if I just basically add one more thing, just to make an analogy, what we do in WhatsApp is all our relatives are every day sending us good morning and good evening message, which is associated with every day. So what we have done, we have made a family group of that in WhatsApp,
Yes. And
and
then everybody
again
can-
so that we need not to be harassed every time when we open our WhatsApp.
True.
So again, as Reddy sir has mentioned, few things I have to just add. Even if we are abolishing the Inspector Raj, through the complicated labor laws, it will give more power to the basically labor inspector or labor
Yes.
basically department to take interference in the industries. So we want to simplify, as sir has mentioned, ease of basically doing the business. So we want employment generation also, because the ceiling was 100. Again, many of the employers do not basically prefer to employ a permanent employee, or you can say basically contractual workers there. Then there is also one reason ki we want to generate employment. So again, all these factors collectively play a role in codification of these labor laws.
Absolutely. Absolutely. In fact, there is one more thing that I will just add to the talks, and I'm just qualifying what both my colleagues said. See, the problem has been that, as Reddy ji also mentioned, Raj also mentioned, that number one, we are having outdated labor laws. Laws formed in 1926, laws formed in 1935, 1947. They were different days, different types of workers. Also, there is other challenge that multiple laws mean that labor is rather worse off, because even if a rich employer has negative malafide intention, they can hire a better lawyer and defeat the labor on the clause of multiple clauses being present. Also, we need a labor law which matches today's world, where things are changing very quickly. India did not allow contractual labor beyond 10% of the workforce, and that also in particular sectors like textile. Now that meant that even our government would sometimes exploit this clause. Many of you would have noticed that in colleges, the government would not give a contract of more than 4 months to the teachers. Now, what labor law proposes is we can have long-term contracts. They're calling it fixed-term labor, fixed-term contract. Now, many people say permanent naukri nahi hai. This is what we need to understand, that in a modern world, your job is permanent based on your efficiency. It is not permanent by a legal consideration. Because even if government gives you a permanent job, if you are not productive, you will not be able to earn sufficiently, and that will keep you in the low level equilibrium. So that is the incentive. We will discuss the challenges, but this is the intention that has been taken up. Nitish, पॉलिटिकल बैकग्राउंड क्या आप सजेस्ट करेंगे, कैसा रहा गवर्नेंस के हिसाब से?
Sir, basically there are 5 dimensions of governance, in which the economic dimension and administrative dimension, it's of immense importance, because to do anything we need to have an efficient utilization of the administrative machinery, which includes finances and human resources. And for having good ease of doing business and also having macroeconomic stability,
right,
we need to ensure that we have a growing GDP, for which again we required a balance of human resources and the financial resources. So these laws are in this direction, that we ensure that the rights of the human resources are protected, as well as the employers are not reluctant to generate jobs.
True.
For example, sir, the way we discussed about the fixed term employment being considered as a employment which is not as but good as the permanent employment, it was because of the absence of gratuity.
True.
It was the absence of the EPFO benefits. It was the absence of the ESIC benefits.
Social security.
Right. And with this new code, where they have specifically mentioned that if someone has worked in an organization for 1 year also, they will be eligible for gratuity. It means in a fixed term, even if your term of employment is 5 years, still you will be getting the similar benefits as a person who is permanent and has worked for 5 years.
And gratuity is available after 1 year only.
1 year also.
Traditionally up to 5 years.
Right. Reddy ji, I am coming to you. That what are some of the main provisions in the wage code bill, if you could highlight?
Sir, the first and foremost for any worker, sir.
Yes.
If he's a tailor, there is a great bureau, administrator, sir. Payments, sir. So here in the labor codes, the first one is the code on wages. So here it covers 3-4 things. Number one, sir. So what exactly the wage? They clearly mentioned right now. So if any employer paying some payment or salary, it should not, if they are giving a lot of allowances right now, sir, that should not cross 50%. If they are paying more than 50 right now, that's considered as a wages right now. So now they fixed a cap, sir, indirectly. They have clarity right now how to calculate wages. Number 2, sir, there is a flexibility in payments. Now you can pay weekly, every 15 days, monthly, sir. Now traditionally what is happening right now, they take some work, they delay the payments. Now they say after completion of month, maximum 7 days. So you have to pay within 7 days, sir. Now even because of some reasons, company may be removed some worker. So now they have to settle everything in 2 days, sir. Traditionally they take 31 days, sometimes 6 years. There's a lot of litigations.
Yes.
Now indirectly they simplified the payment part. Now one more thing, sir, payments now they can pay in an online form, in check form, in cash form, no kinds, sir. So now they have clarified, they give flexibility to payment methods also. And most importantly, sir, here the gratuity, sir. Here traditionally you have to work in a particular establishment for 5 years. That is only for organized sector. Now the fixed term employee, traditionally, sir, we think job means permanent job. So where there's a fixed salary, PF,
Yes.
insurance benefits, etc. But now we are changing the definition of even worker also. Now company has the freedom to recruit permanent employees, some fixed term employees, some contract workers also. Sir.
Right.
Now the beauty here with the fixed term employees, the way permanent employees getting all the benefits is equally benefiting. Now he gets social security benefits. After 1 year, sir, now he is going to get even gratuity also.
Yes.
Now how do we calculate, sir? Whatever he is drawing the last salary, they take the salary divided by 26 days into number of years he is working. So now they were clarity in calculation of gratuity also.
Yes.
They kept a maximum limit 20 lakh rupees. So indirectly, sir, it's like a thank you kind of. So once you're working with a company for a few years,
Yes.
it's like a thank you kind of gift. That is also clearly mentioned right now. And one more thing, if it's the code and wages right now, they simplified, sir. For example, the floor wage. Right now, national government or union government kept the floor wage, but most of the states not following because it's not mandatory legally. Now they mentioned, now the committee appointed, sir, within maybe 5-6 months, they submit
Yes.
what exactly the floor wage, depending on the cost of living, etc.
Yes.
They may fix some rate. Nobody can pay less than that rate. That's the one thing, clarity on national floor wage.
Even to unorganized workers.
Yes, now all workers, sir. Now when you are talking code wages, it's for organized as well as unorganized, sir.
Yes.
So there is no differentiation right now. And one more thing, here, there's a minimum wages. State governments may fix above the floor wage. Now every state has a freedom, sir. Now generally, let's say you have more experience, somebody has less experience, so they cannot get the same salary, sir. So now based on the experience, the concerned state may fix the minimum wages. And one more thing, the equal pay for equal work. Now traditionally the men is favored in payments, unfortunately. So now it is discouraging the female labor force participation. So it's a kind of demotivation. Because I am working, you are working, payment should be same. Now they are treating equal pay for equal work for male also, female also, even third gender also.
Right.
So indirectly will promote female labor force participation in our country. So without women contribution, we cannot flourish, we cannot make our country as a Viksit Bharat by 2047.
Right. In fact, also this act has been like wage code combines 4 different earlier codes like Equal Remuneration Act, Minimum Wages Act, Payment of Wages Act, etc. राज सर मैं आपके पास आता हूँ. तो ये जो वेज कोड हैं, इनके कुछ प्रोविजंस हैं जिनका सोशल इम्पैक्ट हमें नजर आएगा.
सर वेजेस के कोड के जो सोशल इम्प्लीकेशन है, एक मुझे जो बहुत अच्छा लगा इन टर्म्स ऑफ सोशल सिक्योरिटी वाले में, कोड ऑन सोशल सिक्योरिटी, उसमें एक नया क्लॉज इन्होंने ऐड किया है वेयर अ विमेन एम्प्लॉय कैन कीप बेसिकली पेरेंट्स इन लॉ ऑल्सो एज बेसिकली देयर यू कैन से केयर गिवर. So it is actually transforming the way we understand family in basically India. तो again अभी तक जो हमारा concept था वो हमारा European style concept था, where a married woman cannot basically claim to have a in-laws as her dependent and she can't get benefit for them. But now हमने इसको patrilocal form of basically you can say family system जो इंडिया का है, कि after marriage mostly women are living with her in-laws. So in-laws का care is also her responsibility if she's a working woman.
That is good.
So that is what transforming and recognizing the Indian form of the families. अभी तक तो western form of family में था. दूसरा सर इसने care giving work को भी recognize किया. So again there was a act called as Maintenance of Parents and Senior Citizen Act 2007, which put a responsibility on the children's, but now it is also putting responsibility on the daughter-in-law for basically care of their parents-in-law.
Good
so that way.
Yes.
And sir, one more thing, अभी तक Article 46 के अंदर we were making state as responsible factor for elderly cares. अब basically in-laws में भी आ जाएगा ये. So these are the 3 things which I see a change in the basically case of social security. And एक जो है women in night shift वाला भी इसमें provision किया हुआ है. So women in night shift से क्या होगा, जैसा रेड्डी सर भी बता रहे थे कि more women will be now feeling safe to participate in the you can say work, and that will increase definitely our GDP as well as basically gender empowerment. दूसरा ये concept को
labor force participation rate है वो,
yes, that is going to definitely
for the women especially, yes.
For the women that is going to definitely pick up. दूसरा एक और है कि traditional concept है कि male are the breadwinner, that is going to be affected with this because most of the women who are basically willing to work because of the norm and basically security issue, they were not allowed by the employer and government also do not push for it. But now if there is a safety and security issue and women is willing, a women employee is willing, there should be no restriction.
एक तो when we are employing women as fighter pilots,
correct. So
I see no reason for a hazardous work for women
work
clause.
And segregation.
That is outdated again.
Rightly said.
इसमें
So
दोस्तों
colonial law वाला जो हमारा mindset है वो भी अब हमारा कम हो रहा है.
इसमें दोस्तों मैं एक बात ऐड करना चाहूँगा और that कहाँ एक अखबार में आप पढ़ेंगे, हार्दिक तुम्हारे क्वेश्चन का जवाब भी दे रहा हूँ इसी के थ्रू. You will read many things in newspapers critical. Some things can be criticized, but I'll tell you one thing here. When government says that we will make 50% of your wage as minimum, which Reddy sir was also explaining, as the minimum need of your total wages that you are paying, तो समझिएगा ये क्यों किया गया. We have a law in India that whatever is the basic wage, 12% of that has to be contributed by the employer and deducted from employee's salary to contribute to the provident fund of the employee. Now what employers used to do was they will deliberately reduce the basic wage so that their obligation to pay the provident fund 12% becomes lesser. So कहने के लिए एम्प्लॉय को हाथ में ज़्यादा पैसे मिल जाते थे कॉस्ट टू कंपनी के नाम पर, CTC कहते हैं जिसे ज़्यादा पॉपुलर टर्म्स में. But the savings for future will be compromised because lesser basic wage will mean lesser contribution in the provident fund. Now, in the short run, it can happen that if the same CTC remains, same salary remains, and if the person was getting a salary which was more than 50% of the basic pay, then their take-home salary might become slightly lesser. But it will also contribute to their provident fund, which will mean long-term savings will be higher. Also remember, government rather is defining things better rather than private or government employees being reduced in their structure. Imagine we did not have benefits for gig workers earlier, definition for them also. एक और बात सोचिए, पहले बहुत employees क्या करते थे, employers क्या करते थे, they would show their employees as consultants and then save their tax payment. Now the government says your consultants are also a part of your employment only. So as the laws become more implemented, we will see some clarifications. But at the moment, एक बात और इसमें समझिएगा, this law was passed with political consensus developed over all the parties. And अभी मुझे बड़ा आश्चर्य लगा कि केरला की सरकार इसको लेकर थोड़ा नाराज है, while the 2021 bills were drafted by the Labour Minister of Kerala. So this was
same government has continued also.
And the same government has continued. So you know, politics will have its own role, and I fully understand that. But if you ask me, India would need labor law reforms. Otherwise, what is happening in India is that several complicated laws are discouraging labor employment itself. मैं मजाक में अपनी क्लास में भी एग्जाम्पल देता हूँ कि मान लीजिए मैं आपके घर पे झाड़ू पोछा करने आता हूँ, बर्तन करने आता हूँ, साफ करने, और मान लीजिए आपके कपड़े भी धो देता हूँ. एग्जाम्पल दे रहा हूँ, तुम लोग उम्मीद मत लगाना. तो उस केस में अगर मैं अगले दिन तुम्हारे पास आऊँ एंड इफ आई टेल यू आई एम इन इंडस्ट्रियल डिस्प्यूट्स एक्ट एंड यू विल हैव टू गिव मी ऑफ ऑन एवरी वीकेंड, एवरी नेशनल हॉलीडे, casual leaves, apart from that sick leaves, and then unpaid leaves. Other than that, if you want to remove me, you will have to give me 3 months of salary. If you don't give me 3 months of salary, you will have to give me 3 months of time period to serve you. Apart from that, you will have to contribute 12% of my basic salary to my provident fund and give me gratuity also at the time I am leaving you. Apart from that, if you want to replace me, you will have to take permission from my trade union. Next day, you will go buy a washing machine and a dishwasher, replacing labor by capital. So we have to understand, एक है theory में सब कुछ बढ़िया लगे, एक है practice में क्या हो पा रहा है. So if you look at India's labor situation in the last 50 years, 60 years, 70 years, 83% workers in unorganized sector, 89% workers in informal sector, and that means they lie unprotected. और formal workers भी protected नहीं है. किंगफिशर बंद हो गया, एम्प्लॉय को अपना प्रोविडेंट फंड भी नहीं मिला, एंड वी डोंट से एनीथिंग अबाउट देम. जेट एयरवेज सेम स्टोरी. सो प्लीज बी क्लियर दैट अ रिफॉर्म विल बी नीडेड. तो नीतीश, इसी बात पे आपके पास आता हूँ कि गवर्नेंस के ऊपर क्या इफेक्ट पड़ेगा इन चेंजेस पे.
सर फर्स्ट
जैसे वेज कोड
सिमिलर है कि फ्रिक्शन मे अपीयर इन बिटवीन द व्यूज. जैसे आपने क्लियरली बताया दैट केरला इनिशियली दैट वाज on the same page, but now they are not happy with the bill. Reason being that abhi tak it had been a part of a concurrent list, and because of this, whenever there is a friction, the state had the clear answer that the union government law will prevail. What can we do about it? But now a union government has simplified the codes. They have provided them a direction that this is what is to be done. For example, now the term labor, the term worker, it will mean the same thing all over the country. Otherwise, it might have meant differently. In a state like Jharkhand, it might have meant differently. In a state like Punjab, it might have meant differently. In a union territory of Puducherry. But now everything will mean the same. They have also mentioned that this is the floor wage and this is the minimum wage. Right now, the state's policies are linked with the minimum wages. So the state governments, they used to keep the minimum wages similar to that of the union government requirement. But now if they are keeping it as minimum wage, when it is identified, the state did not want to do anything better than what the union government perceive it to be done.
True.
So sir, the populistic excuses that was initially there, that might be difficult for the state governments, and that is an advantageous situation for the people who are working in the economy, particularly sir, the gig workers and platform workers, because they were the ones who were most affected and they were the ones who are more eager to become a part of any labor code or any kind of industrial relations.
True, true. Reddy ji, what are the main features of Industrial Relations Act?
Sir, this is very controversial, sir. Traditional in India, the employer and employee relation is always debatable, sir. There are so many places, unfortunately, they do sometimes more dharna than manufacturing or some activities. So now government want to bring a balanced approach. So right now they clearly define the fixed term employees. Indirectly now companies have freedom to recruit, sir. Number two, there is a reskilling fund. So they have to deposit 15 days wages, so that once they remove or retrench some worker, they can use that money for reskilling the whoever vulnerable. Number three, sir, the trade unions traditionally, even few people form a group and do protest. Now in India, multiple political ideologies, multiple groups are there. So sir, you shocked. I was in Andhra one day. I went to one factory. National August 15th, sir. We got independence. Everybody knows. Then I went just to talk. Three people called me 3 different timings. I told one factory, why 3? That is another one party, another party, third party. So 3 parties hosting 3 times national flag, sir. That is how they divide, unfortunately. So this right now they have clarity. Even to do the dharna protest, now you have to give some prior notice also.
14 days.
14 days notice. Traditionally, what they do, sir, they can suddenly start. They come morning and they suddenly stop. Then it impact
for a negotiation also in 14
course,
days if there is a possibility.
Yes, at least now they can mediate.
Correct.
They can discuss in a better manner. And most importantly, sir, that standing orders. Now they increase from 100 to 300 workers. So now indirectly, companies recruit more. Generally, there is a lot of negative about this provision. So technically, people may say government can, right now companies can hire easily, fire easily. But the truth, sir, now they may recruit more people, sir. Now with the fear, no, I may not recruit. Now I can recruit more people. More formalization will improve. Now I am taking some contract workers, etc.
And in this I will add one thing. Yes, I'm sorry, I'm interrupting. If people are worried hire and fire,
yes, sir.
In the Industrial Relations Code, there are specific conditions now established.
Yes, yes, sir.
Under which only a firm can remove the worker.
True, sir, yes.
Otherwise they cannot.
And sir, one more thing here. There is a grievance redressal body.
True.
Even the female traditionally neglected, now female also represented, sir. So they can tell their concerns. And most importantly, sir, now the various types of workers recognized, like journalists. So traditionally cine workers, then what you call the YouTubers. Right now they recognized all are as a worker. And one more thing, sir, if you see the tribunals, if they have any problems are there, disputes are there, now one judicial member is there, one administrator will be there. So they will sit and discuss the things. And most importantly, sir, here the intention of Industrial Relations Code is to maintain harmony, the peace in the workplaces.
Yes.
And so that we can promote our manufacturing capabilities, to increase our exports. So right now, if you see compare with China and America, so right now there is a lot of competition in the global economy also. So we cannot be traditionally thinking, no, I should protest.
So how do they have labor laws in America already?
Sir, if you see right now America and China, sir, but China is a little bit complicated, sir. In paper they say something, they do something. But if you come to America, they have very flexible labor laws, sir. They can hire for 1 day, 1 hour, 1 week, 2 days, 3 hours. So there is a more freedom, sir. But their states play important role in America. and they have a stringent what you call minimum wages, sir. So the minimum wages rules are very strict there, and occupational safety, sir. So if you see, go to some occupational place there, they maintain good sanitation facilities, drinking water. If you visit office like Google, Microsoft, you feel like it's like 5-star hotel, sir. So they provide all amenities. So work culture is very good there in America. Coming to the China, sir, for the main focus is productivity. So जितना काम कर सकते हम ले लेंगे उससे. So they are in the कानून, in the law they says this is a minimum wage. Sometimes they don't pay even minimum wages.
Yes.
And but they provide, sir, crutches.
And their minimum wage is $3 per hour.
Yes, sir. So they say you cannot do protest also.
Yes.
So they are not, sir, because of lack of democracy, we cannot compare with China.
True.
But if we compare with America or China, right now India has a middle path, sir. So some areas it may favor employer, some areas employees. So kind of it's a win-win situation for both the employer as well as employee, and the industrial relation code that government is going to implement from November 21. Sir.
I would like to comment this, because as sir initially mentioned that we will be talking about the labor unions. So the new code has made it very clear that until unless you do not have 51% participation of the people working in that organization, you cannot have a labor union.
Earlier it was only 30 workers if you could get.
Yes, sir. And
They do lot of hooliganism also in the basically premise.
sir, I have worked in an organization where there was a labor union, and we can say that there is a very big difference between the permanent employees and the casual or the temporary employees, and the only difference is because they could not become a part of the labor union. Second thing that they have mentioned here, that if any group of employees want to strike, and it is a perception that constitution provides them a right to strike, which is not there. It is on the basis of these codes only, Industrial Disputes Act and the other Factories Act. Initially they could have only avoid coming to work by giving a notice of 6 weeks, that if you give a notice for 6 weeks you may not come to work on that day. Now they have extended it to 8 weeks, that is 60 days, 2 months. So striking or not coming to work has also become difficult, and also they have clearly mentioned mass leaves will also be considered as a strike. So they are also trying to include the challenges that were coming into the implementation of the ease of doing business because of the labor unions, which are politically motivated.
Yes. इसमें मैं एक क्लैरिटी देना चाहता हूं दोस्तों आपको, क्योंकि जनरली अगर हम इसको आइडियोलॉजिकल व्यू से देखेंगे तो हमें लगेगा कि लेबर यूनियन को दबाया जा रहा है, पर देखिए होता क्या था हमारे देश में, और 80s में 90s में भी, आज भी बहुत जगह ये हो जाता है, बट 80s 90s में तो बहुत ज़्यादा होता था कि लेबर यूनियन पॉलिटिकल पार्टीज कंट्रोल कर लेती थी, और जो लेबर यूनियन के हेड होते थे फिर उन्हें अपीजमेंट की जाती थी फैक्ट्री ओनर के द्वारा, और जो वर्कर है वो डिप्राइव्ड ही रह जाता था। तो जो गरीब वर्कर है उस तक चीज़ें नहीं पहुंचती थी, बट लेबर यूनियन का लीडर बनना अपने आप में एक करियर ग्रोथ था। यहाँ तक पाया गया था 1980s में, एंड दिस इज रिसर्च डन बाय प्रोफेसर J.C. संडेसरा। देयर वाज अ रिसर्च डन, ही फाउंड that many trade union leaders in large scale enterprises were richer than the senior managers of that enterprise.
So this was considered as a ladder to join politics also.
Politics later,
they are not even in that organization.
And also to come to work and not to work.
Yes.
It is one of the way that how can you earn salary without money.
इसमें दोस्तों लेकिन एक क्लैरिटी भी दूंगा मैं, जो मेरा ख्याल है, आप डिसएग्री कर सकते हैं। The clause where they say that you cannot strike when negotiations are going on. There is a clause that negotiations will go on and you cannot go on strike when negotiations are going on. Again, 56 days can be set as the upper limit, because otherwise the employer will keep stretching the negotiation and employee cannot go on strike. तो जितना important है कि employee misuse ना कर सकें अपने provision को, उतना ही important है that employer भी misuse ना करें अपने प्रोविजन को। लेकिन आप समझिएगा और सब लोग सोचिएगा, एम्प्लॉयर की तरह सोचिए, एक एम्प्लॉयर भी अपने एम्प्लॉय को हटाने की नहीं सोचते ओवरनाइट। आप सोचिए हमारे घर में ड्राइवर्स होते हैं, कुक्स होते हैं, हेल्पर्स होते हैं, कभी कभी वो बिना बताए 15 दिन के लिए गायब भी हो जाते हैं, लोग इमीडिएटली उन्हें नहीं हटाते। People wait, they come back, take explanations, and if they are good workers, they're taken back also. What I'm only trying to say by this is, the perception should not be only a Marxian perception that every employer is sitting down to fire the employee, and the perception should not be a neoliberal perception that employees should not be protected, otherwise they will misuse. the perception has to be in between, that you need to give fair protection to employee and fair protection to employer for a good industrial relation. Reddy ji, I'll come to you once more for a question. That how about the social security code? राज मैं आपके पास भी आऊंगा इसमें एक सवाल.
Sir, the beauty of social security code right now, sir, it is including all the workers, number one, sir. Especially the gig workers, the platform workers. Sir, there is a guy, construction worker, part of gig. He may work for a day, tomorrow he may go to other places. But the platform workers working with Zomato, Swiggy, Ola, Uber, they work with a particular platform, sir. So it's called aggregators. So right now we are covering the social security like Provident fund, insurance. So all these benefits to the all kinds of workers right now. And one more thing, now the companies who are recruiting for temporary basis, that's called traditionally, there is no employer-employee relationship, sir. There is no what you call traditionally there is agreement or contract. Now I can work per day. It is a gig matlab task basis, sir. You hire me for hour, you pay some amount, done. No more relation with you. So right now they are covering gig workers, platform workers, etc. And one more thing, sir, here they create a fund, a social security fund. So now the platforms who are recruiting for temporary basis, they have to contribute whatever the turnover is there, 1 to 2% they have to contribute. So government can use them for the protecting the workers if something went wrong, or may introducing some schemes like for unorganized sector like pension schemes, etc. And the beauty of this social security, sir, there is a mandatory maternity benefit is there for 26 weeks right now. So traditionally in India, the companies won't recruit the married women because they have to pay maternity leave, etc. Sir. So right now indirectly government says they are treating all the workers equal manner. So indirectly they want to hire such a way. In the industry, that occupational safety it mentioned, sir, the female can recruit it now, the day shift also, night shift also, that is the before 7 p.m, after 6 p.m. That means indirectly the night shift they can work. So this code is going to transform our unorganized sector, and they protect if something happened in the case of any accidents, etc. So indirectly, sir, it is going to improve our formal sector. Now there is a mandatory appointment letters are given. Now it doesn't matter, organized, unorganized, call letter is mandatory. So indirectly, sir, it is going to impact our vulnerable sectors traditionally, now the gig workers especially. Now India focusing a lot on startups, e-commerce platforms. So in upcoming years, sir, you may see more people, even workers, permanent workers are not happy with a particular job. Let's say, sir, let's say I love photography, sir, but I am teaching. But I want to do something in photography also. Now government is, okay, fine, you can work as a photographer also. So now they're recognizing them as a workers. Now traditionally they don't get credit. Let's say if you want to go for loan purpose, sir, they ask your fixed salary. So where you are working, give me the call letter, also 6 months salary certificates. Lot of complex provisions are there. So through this new safety and social security, etc. Now they can show as a proof. So these are my contributions of PF insurance or GST contribution, etc. Now they can get easily credit also. So they can indirectly benefit their growth process also.
गिग इकोनॉमी को जो इंक्लूड किया गया है, क्या आपको लगता है इससे सोशल अपवर्ड मोबिलिटी के चांसेस हैं?
डेफिनेटली सर, एक तो अपवर्ड मोबिलिटी का भी है, एंड मोर सो इन टर्म्स ऑफ रिकॉग्निशन, बिकॉज व्हाट हैपन इज सर, मोस्ट ऑफ द गिग इकोनॉमी वर्कर वर अनसिक्योर्ड अंटिल नाउ विद लैक ऑफ एनी यूनिफॉर्म लॉ. व्हाट हैपन इज, सपोज मान लीजिए कोई ओला या उबर का है या कोई रैपिडो का ड्राइवर है, मान लीजिए उसका कोई एक्सीडेंट हो गया रास्ते में,
तो कोई
देयर इज नो बेसिकली केयर फॉर देम. नाउ देयर इज अ बेसिकली 1 to 2% of the annual turnover from all these aggregators should be basically deposited into a government account where they will be providing some social safety net extended to all.
That is very important.
That is going to change. Second thing is, sir, जैसे ऑक्यूपेशन, रेड्डी सर ने एक पॉइंट बेसिकली बोल रहे थे, तो उसी में मैं ऐड करूंगा कि सर इसमें एक वर्क फ्रॉम होम को रिकॉग्नाइज करना, which was until now was going on without recognition only.
True.
So now if you are working from home, you are treated at par with a regular employee also, which were earlier basically miss out. Then on the occupational safety point of view, the condition of work should be basically such that will inspire a person to work. Like many of the offices or basically premises were having no basically restrooms or washroom or drinking water facility. So all these are part of occupational safety, health and working condition. इसमें सर 2-3 पॉइंट मैं बस ऐड करूंगा कि फर्स्ट एंड फॉरमोस्ट जैसे रेड्डी सर ने बोला अपॉइंटमेंट लेटर होगा, इन विच अपॉइंटमेंट लेटर you will not just have the basically date of appointment, but what role you are going to have, what kind of remuneration you are basically eligible, everything will be in paper. So that makes you eligible for applying for loan and other kinds of financial benefits you will have. Then as I mentioned, work from home is recognized. Then there is a facility for crash and other kind of basically childcare, which is promised by the government in Manrega also, but there was no such facility in the organized sector in a legal manner. But now they are creating that. And last one in this is maintenance of digital record of everything so that we can track it down.
Yes.
So there is a universal account
and some
number.
real time information will be.
Yes sir. So उसमें क्या हो रहा है कि पहले multiple basically accounts were numbers were there, due to which ESI or basically other provisions were making complicated. Now there is a universal account number in that way, and 26 crore are already registered.
Now 32 crore.
Yeah.
On
So again Shram portal pe. So that will bring more basically facilitation.
Right.
Sir, one more thing I would like to
Yes.
add, that now even if one employee is working in an hazardous sector, then also they will be eligible for ESIC benefit.
This is
Previously,
the
which was
occupational
10.
safety.
Yes, sir. It is important. Previously, when 10 employees were there, then only they were eligible. Now, even one worker, if they are working in a hazardous sector, they should be eligible for ESIC.
There is one more good thing that has been introduced in occupational safety, health and working conditions and workplace code, that there is protection against sexual harassment as a gender neutral thing. So earlier only women were allowed to complain. Now even men can complain. So
Sir, it is actually, yes, sir. It is actually for transgenders more important.
true.
One point here, sir. Interstate migrant workers, traditionally ignored. Now they give a clarity, the definition of interstate migrant workers, and there is a uniform single registration that is the Aadhaar linked right now. Let's say I'm working right now in Delhi, sir. Tomorrow I'm shifting to, let's say, Andhra or Kerala or UP, Bihar. So previously there is a multiple registrations are there, complication. But now there is a one country, one single registration number, sir.
Yes, they're calling it UWIN.
Yes,
Universal Workers Identification Number.
Yeah.
UWIN is there. So I will begin with Reddy sir and then I will come to Raj sir and Nitish sir, both of you. What do you think can be possible challenges in these codes?
Sir, if you see our Indian, traditionally our mindset, sir, we enact a beautiful legislation, sir. From day one with the constitution, we took 2 years, 11 months, 18 days, almost 3 years. It is a very beautiful law, no doubt, sir. But implementation, sir. So the number one, still it is on the paper. So it is a part of a concurrent list. So states, they have to come up. So they have to mentally prepare and they have to implement it at the grassroots. Number one, implementation challenge, sir. Number two, creating awareness. Now, government claims we consulted all the trade unions, various state governments. It is not a one-day process. But right now there are some protests are happening. So it is a duty on the government also to convince them. Because, sir, if I am in ruling, I should take moral responsibility to convince opposition parties or the regional parties or the concerned state governments to tell positives of these legislations, impact on our economy, especially sir, manufacturing sector, exports, the small scale industries, MSMEs, and most important startups, impact on female labor force participation, and the gig workers, platform workers, and third gender, so cine workers, journalists. So it is going to impact everyone, sir. So it is a moral duty on government to create awareness also. Now, last few days, if you observe, government is advertising a lot. So they are working very hard in that, sir, no doubt. But number three here, main center-state coordination is needed, sir. That is a major concern. Simply bringing something at national level cannot make things into real in our country. So we need a grassroots empowerment. So we must involve the local governments also, along with the states, so that we can implement better these labor codes.
Raj?
Sir, Reddy sir की बात को आगे बढ़ाते हुए कि main thing is about the implementation, not about the law. So law may be what basically expressing we want to pursue, but how we are implementing is going to bring the change. तो इसमें कई सारे challenges हैं in basically many ways. The worker का एक challenge worker के points of view से है कि if this happened, am I going to lose my job? या will small businessmen follow the rules as they are following? क्योंकि आज भी बहुत सारी companies हैं और बहुत सारे organization हैं, they are openly flouting the or violating the rules and there is no basically remedy for it. दूसरा unpaid domestic help is not covered या workers are not covered, ये एक challenge है. तीसरा बहुत सारे जो charitable organization है, they are also excluded from this basically safety code, NGOs and all. That is also one. And again, many people are saying it is too early and too fast for us to basically even join in. So there is no proper time given. So that is always a complaint whenever some kind of change like this. And from employer point of view, they are complaining that there is possibility of higher cost, because now they have to maintain all this kind of thing and have to give the wages 50% and all this law. So there was some genuine concern, and the way forward is developing consensus so that we'll have worker protection at hand, certainty and clarity from the part of employer, as well as some kind of industrial production or production we can pursue, so that we can occupy our surplus labor.
Nitish?
Sir, implementation se zyada concern is adjudication. That if someone is not implemented, then what next? Then there will be more pendency of cases, and the labor who is feeling that they are vulnerable, how can they continue to stay in a legal process which might take some time, even if it is taking minimum 6 months.
True.
But a person who is in a legal hurdle, it will be difficult for that person to continue to search somewhere else. And sir, we all have a digital data. We know that this particular employee is in a legal conflict with the previous employer. They may not get employment in future.
Yes.
So
इनफैक्ट इसमें एक और भी चीज़ मैं ऐड करना चाहता हूँ. दो चीज़ें. नंबर वन इज इंडिया हैज़ अ लॉट ऑफ एम्प्लॉयमेंट क्रिएटेड थ्रू ओरल कॉन्ट्रैक्ट, and oral contracts cannot be adjudicated very easily. Proving them in a court of law will be difficult. Another challenge is that we have talked about making an industrial tribunal for fast tracking the case, which is a good welcome change. But the challenge we have seen already that even tribunals in India sometimes get delayed in their judgment because of overburdening. You know, I will come to a conclusion telling my audience that if we actually want to protect the workers, we should be focusing on skilling them better, training them better, creating more entrepreneurship with ease of doing business so that there is more work opportunity, and expanding the economic system with inclusive growth, better infrastructure in remote areas, and that will give more protection to workers with good labor laws, no doubt, which we are trying to achieve. But as my colleagues said very correctly, implementation will be the key. That is what we're working on and waiting for. So I hope it helps you. I will, before ending, Amiya, I'm answering your question. It will still be 48 hours. Your working hours cannot be more than 48. Either you can work 12 hours 4 days a week or 8 hours 6 days a week, and breaks will be calculated as breaks. They can't be working hours. You're not working when you are on a break. So it will be like that. So I'm very thankful to all my colleagues. It was a very intense and wonderful discussion. I learnt a lot. So thank you all of you also for listening and watching. अगर आपके कोई भी सुझाव हैं, कोई चीज़ आप हमें बताना चाहते हैं, तो ज़रूर कमेंट बटन में बताइए. अगर आपको PDF चाहिए इस डिस्कशन का, आप कमेंट में पूछिए, हम आपके साथ PDF शेयर करेंगे. और अगला क्या हम टॉपिक डिस्कस करें, शेयर इट विथ अस. All the best to all of you from Next IAS side. Keep making us grow as you have, as your family. We are there to support you always, anytime, any point of time. Jai Hind.